Welcome back to the podcast. Today, we are talking about a question that sounds futuristic but is already very practical. What happens when AI, robots, smart devices, autonomous vehicles, or software systems cause harm?
Exactly. People often ask, can AI be liable? But legally, that is usually not the best first question.
So, what is the better question?
The better question is, if a digital system causes harm, who should compensate the victim, on what legal basis, and how can the victim prove the case?
That already sounds much more complicated than simply saying the robot did it.
It is, because in real life, the robot or AI system may be only one part of a much larger ecosystem. There may be a hardware manufacturer, a software developer, a data provider, a cloud provider, a company operating the system, a user who changed the settings, an insurer, and possibly a third party who supplied a faulty update.
So, the difficult question is not whether the machine did something. The difficult question is how to connect that event to a legally responsible person or company.
Exactly. Traditional tort law was largely designed for a world where a human being does something wrong, causes damage, and can be identified. Emerging digital technologies make every part of that chain more difficult.
Let us begin from the beginning. What is tort law actually trying to do?
At its core, tort law tries to answer a simple question. When one person suffers harm, should someone else compensate them?
And the answer depends on several elements.
Yes, a very simplified structure is this. First, there must be legally recognizable harm. Second, there must be a causal link between the harm and some conduct, product, system, or risk. Third, there must be a legal basis for liability, such as fault, a defective product, strict liability, vicarious liability, or contract. Fourth, the victim must usually prove enough facts to satisfy the court. And finally, we need to ask whether insurance, contribution by the victim, time limits, or other defenses affect the result.
So today we will walk through that entire structure.
Yes, think of this episode as a map of AI liability law.
Part 1. Why AI challenges traditional tort law.
Before we go into the details, what assumptions does traditional tort law usually make?
Traditional tort law often assumes that there is a human actor, a relatively clear cause of harm, and a stable product or activity.
Can you give an example?
Imagine a driver runs a red light and hits a cyclist. The usual questions are relatively straightforward. Did the driver act negligently? Did that negligence cause the cyclist's injury? What losses did the cyclist suffer?
And AI changes that.
Completely. Imagine an autonomous vehicle hits a cyclist. Now, the possible causes may include the vehicle's sensors, the driving software, a software update, incorrect map data, a camera malfunction, a network issue, bad weather, a third-party data supplier, a human safety driver, or even the cyclist's own conduct.
So instead of one human error, we may have a network of possible causes.
Yes, and not only possible causes, we may also have multiple people or companies involved. One company made the sensors, another designed the software, another provided cloud computing, another supplied traffic data, another company operated the vehicle, and the user may have failed to install an important update.
That means a digital accident can be technically complex, legally complex, and commercially complex at the same time.
Exactly. That is why emerging digital technologies challenge traditional tort law.
Part 2. Damage. What kinds of harm can be compensated?
Let us start with the first requirement, harm. Surely that is the easiest part. If somebody is injured, there is harm.
Physical injury is usually the easiest category. Most legal systems clearly recognize harm to life, health, and bodily integrity.
For example, a delivery robot knocks someone over and they break their arm.
Yes, that's a classic personal injury case. The difficult questions come later. Who is liable and how can the victim prove it?
What about property damage?
Physical damage to property is also commonly protected. If a smart oven catches fire and destroys your kitchen, that's normally recognizable property damage.
And what becomes more difficult in digital cases?
Several types of damage. For example, pure economic loss, damage to data, damage to digital assets, privacy harm, or losses caused by an automated decision.
Let's unpack pure economic loss. What does that mean?
Pure economic loss means financial loss that is not directly connected to physical injury or damage to physical property.
Could you give an example?
Suppose an AI trading system gives incorrect recommendations and an investor loses money. Or suppose an automated hiring system wrongly rejects a qualified candidate and that candidate loses a job opportunity. These may be serious financial losses, but they're not necessarily connected to bodily injury or damaged property.
And legal systems are often less willing to compensate that kind of loss.
Correct. Many tort law systems are more cautious about pure economic loss. They may require a contract, a special duty, a specific legal rule, or some other basis for compensation.
What about data? If defective smart home system deletes all my files, surely that should be compensable.
Morally, many people would agree. Legally, it can be complicated. Traditional product liability law was designed mainly for physical property. Data is intangible, so the question becomes, is data legally treated as property for the relevant rule?
So if a defective smart home system deletes all the homeowner's security recordings, the homeowner may face a legal gap?
Potentially, yes. They may have a contract claim, perhaps a negligence claim, maybe a data protection claim in some circumstances, but traditional product liability may not clearly cover the loss.
So the first lesson is that not every real-world loss automatically fits into an existing legal category.
Exactly. AI does not necessarily create completely new kinds of harm, but it makes old categories like data loss, privacy harm, and pure economic loss much more important.
Part 3. Causation. Did the technology actually cause the harm?
This seems to be the heart of the problem. It is one of the hardest issues. The victim usually has to show that the defendant's conduct, product, system, or risk caused the damage.
In a simple car accident, that might be easy.
Yes, if one driver crashes into another car from behind, the physical sequence may be relatively clear.
But in an AI case, the accident may have many possible explanations.
Exactly. Let's use a smart smoke detector as an example.
Okay.
Suppose there's a fire in a smart home. The smoke detector doesn't trigger an alarm. The homeowner suffers serious property damage.
The victim can easily prove that there was no alarm.
Correct, but proving why there was no alarm may be much harder.
Maybe the wiring was broken?
That would be relatively easy to inspect. A technician might see that a wire was disconnected or burned.
But what if the problem was software?
Then we may need to examine firmware code, sensor behavior, device compatibility, software version history, network records, and update logs.
And that sounds expensive.
Very expensive. It may require software engineers, forensic experts, electrical engineers, and possibly cybersecurity specialists.
So the victim may know that something went wrong but still be unable to prove the precise technical cause.
Exactly. And this is especially difficult with self-learning systems. Imagine that the AI system changed its internal behavior over time because it was trained on new data.
Then even the original developer might say, "We didn't program it to do that."
Yes, and that raises a difficult question. Was the harmful result caused by an original design flaw, a later update, biased data, self-learning behavior, poor maintenance, or a combination of all of them?
This is often called the black box problem, right?
Yes, in many advanced AI systems, it can be difficult to explain exactly how input data produced a particular output.
For example, why an AI system classified one object as a pedestrian and another as a traffic sign.
Exactly. Or why a medical AI system classified a patient as low risk when the patient was actually in danger. Or why an algorithm marked a legitimate bank transaction as fraud.
And the legal difficulty is not just the AI made a mistake, it's proving what part of the system caused that mistake.
Right. The victim may need to prove both that there was a defect or failure and that this defect or failure caused the harm.
Multiple possible causes. Let's take the autonomous vehicle example again. An autonomous car hits a tree. What possible causes might there be?
There are many. The vehicle may have been poorly designed, its hardware may have been defective, the original software may have contained a bug, a software update may have introduced a problem, the system may have received incorrect map data, it may have misread correct data, a third party may have interfered with the system, or the user may have failed to install an important update that would have prevented the collision.
And several of those could be true at once.
Exactly. That's called multiple causation or alternative causation. The damage may result from one cause or several causes acting together.
How do legal systems deal with that?
Traditionally, there are three broad possibilities. First, the victim may lose because they cannot prove which one of the possible causes was decisive. Second, all potential tortfeasors may be held jointly and severally liable. Third, some more modern approaches use proportional liability.
Can you explain those in everyday language?
Of course, if nobody can prove which actor caused the harm, a strict traditional approach may say no one is liable because the victim has not proven causation.
That is terrible for the victim.
Yes, the victim might suffer real harm but receive no compensation.
What does joint and several liability do?
That allows the victim to claim the full amount from any one of the responsible parties, usually the party that is easiest to sue or most able to pay.
So if the software developer, the car operator, and the update provider might be responsible, the victim could recover everything from one of them.
Potentially, yes. Then that party can seek recourse against the others later.
That protects the victim, but maybe it's unfair to someone who did not actually cause the harm.
That is the main criticism. A company that is only a possible cause may end up paying a large amount because it has insurance, assets, or a local legal presence.
And proportional liability?
That means each potential tortfeasor pays according to the likelihood that they caused the harm.
For example, 50% responsibility for the developer, 30% for the update provider, and 20% for the data provider?
Exactly. It may feel fairer between the potential defendants, but it can leave the victim undercompensated if one party cannot pay.
Evidence tools that help victims. So if causation is so difficult, how can the law help victims?
There are several tools. One is prima facie evidence, sometimes called initial or apparent evidence.
What does that mean?
It means that the victim does not always have to prove every single link in the causal chain. If a certain outcome is typically associated with a certain kind of failure, the court may accept an initial inference.
So the victim says this type of failure normally happens when this system malfunction occurs.
Yes, the court may then treat that as sufficient initial proof, unless the defendant provides convincing evidence to the contrary.
Does that shift the burden of proof completely?
Not necessarily. It may only reduce the victim's burden. The victim still has to present a plausible case, but does not need to explain every technical detail.
What's another tool?
The burden of producing evidence can be placed on the party that controls the evidence.
Meaning the company that owns the logs, source code, and system records.
Exactly. If a company controls the relevant evidence, it may be expected to produce it. If it fails to provide logs that it should have preserved, a court may draw an adverse inference against it.
In plain English, if you were responsible for keeping the records and now the records are missing, the court may suspect that the missing records would not help you.
That is a good way to put it.
Part 4. Wrongfulness and fault. Let us move to fault. Traditional tort law is often fault-based, right?
Yes, in many systems, the victim must show that the defendant failed to act with reasonable care.
That sounds simple. The defendant should have been careful and was not.
It sounds simple until we ask, what does reasonable care mean for AI?
For a human driver, we can ask whether they followed traffic rules, paid attention, and reacted reasonably.
Exactly. But for an AI system, we cannot simply ask whether the AI behaved like a reasonable person.
Because it's not a person.
Correct. We need to ask different questions. Did the developer test the system properly? Did the operator monitor it? Were updates installed? Were safety limits built in? Were logs maintained? Was human oversight appropriate? Did the company follow industry standards or legal rules?
Duty of care. What exactly is a duty of care?
A duty of care is a legal obligation to act with appropriate caution to avoid foreseeable harm to others.
Where do those duties come from?
Sometimes from statutes or regulations. For example, a law may require risk assessments, logging, cybersecurity measures, human oversight, safety testing, and record keeping.
And sometimes there's no specific law.
Then, courts may reconstruct the duty after the event. They ask what a prudent and reasonable actor should have done in the circumstances.
So courts may look at social expectations, professional practice, and available technology.
Exactly.
Legal requirements versus industry standards.
What is the difference between a legal requirement and an industry standard? A legal requirement is binding. If a law says an operator must retain system logs for a certain period, failure to do so is a legal violation. An industry standard may be a widely accepted best practice, but it may not yet be written into law.
So if an AI company ignores an industry best practice, that doesn't automatically make it liable.
Correct, but a court may still consider it. If every responsible company in the field performs regular safety audits and one company doesn't, that may be evidence that the company failed to meet the expected standard of care.
And if the company violated a formal legal requirement?
Then liability may be easier to establish. In some systems, violating a statutory safety rule can shift the burden of proving fault or create a strong presumption of negligence.
Why is fault difficult to define in AI cases?
Because AI systems may operate in ways that aren't fully foreseeable. They may adapt to new data, encounter novel situations, and make decisions without direct human control.
Suppose a developer uses state-of-the-art knowledge when launching the system, but the AI later makes an unexpected choice. Is that automatically the developer's fault?
Not necessarily. The later choice may not be attributable to an original defect in the design. Then where should we look? The question may shift from, was the original code faulty, to, was it reasonable to place this system on the market or deploy it in this particular environment?
For example, was it reasonable to use an AI diagnosis system in emergency medicine without enough human supervision?
Exactly. Or was it reasonable to deploy a highly autonomous robot in a crowded public area, or to use an AI recruitment tool without checking for discriminatory bias?
Part 5. Vicarious liability and the functional equivalency principle. Now I want to ask about vicarious liability. This term sounds very legal.
It is legal, but the basic idea is familiar. Vicarious liability means that one person may be liable for the conduct of another person.
Like an employer being responsible for an employee?
Exactly. Suppose a delivery driver causes an accident while delivering goods for a company. The company may be responsible even if the manager was not driving the vehicle.
And how does that relate to AI?
The key question is, if a company may be liable when a human helper causes harm, should the company also be liable when it delegates the same task to a robot, computer, or AI system?
That sounds logical.
That's called the functional equivalency principle.
Can you explain it in one sentence?
If a machine performs the same function as a human assistant, the law should not automatically treat the person benefiting from that assistance differently just because the helper is non-human.
So if a company uses a human delivery worker, it may bear responsibility for that worker. If it replaces the worker with an autonomous delivery robot, perhaps it should still bear responsibility.
Exactly. Otherwise, companies might escape responsibility simply by replacing people with machines.
But there's still a problem. A human employee can be careless. Can a robot be careless?
That's the difficult part. In legal systems where vicarious liability is closely connected to fault, we need a benchmark for measuring the non-human helper's conduct.
What kind of benchmark?
Possibilities include whether the system met reasonable safety expectations, whether it was properly tested, whether it was monitored, whether it complied with technical standards, and whether it was safer than a human alternative.
Why does the comparison with human performance matter?
Because in many areas, non-human systems may actually be safer than humans. If autonomous systems reduce accidents overall, the law should not create liability rules so strict that society is discouraged from using safer technology.
So the goal is not zero risk.
Exactly. The goal is reasonable risk allocation and better overall safety.
Part 6. Strict liability. Now, let us talk about strict liability. This seems especially important for AI.
It is. Strict liability means that a person can be liable even without personal fault.
So the victim does not have to prove that the defendant did something wrong?
Correct. The victim may only need to prove that a legally recognized risk materialized and caused harm.
What kinds of activities traditionally fall under strict liability?
Historically, new technologies such as trains, motor vehicles, aircraft, nuclear power, pipelines, and high-voltage electricity have often been regulated through strict liability.
Why?
Because these activities are socially useful but carry residual risks. Even when people are careful, serious harm can still occur.
So the law says if you benefit from or control the risky activity, you should bear the cost when the risk materializes.
Exactly. It's a risk distribution principle.
Why is strict liability especially attractive in AI cases?
Because the victim does not need to prove a specific wrongdoing inside the defendant's sphere.
For example, they do not need to identify the exact line of defective code.
Exactly. Nor do they need to prove that a particular employee was negligent. They can focus on whether the system's risk materialized and caused harm.
That seems much easier.
For the victim, yes, but strict liability also raises concerns for businesses and innovation.
Limits, caps, and insurance. How do legal systems balance that?
Strict liability is often combined with liability caps, exclusions, and insurance requirements.
What is a liability cap?
A maximum amount that a liable party must pay. It limits exposure to extremely large claims.
And why would the law do that?
To make risk more predictable and insurable. If liability is unlimited and impossible to estimate, insurers may refuse to provide coverage or charge very high premiums.
So strict liability may be paired with mandatory insurance.
Exactly. Think about motor vehicle insurance. The victim can be compensated more easily, while the vehicle owner or operator can insure against the risk.
Innovation and the chilling effect.
Some people argue that strict liability will discourage AI innovation. Yes, the concern is that companies may avoid developing or deploying technology if they fear high liability exposure.
But the report also makes the opposite point, right?
Yes, legal uncertainty can be even harmful to innovation. Companies may prefer clear liability rules, even if those rules impose obligations, because then they can estimate risk, buy insurance, and plan their investments.
So uncertainty can create a stronger chilling effect than clear responsibility.
Exactly. A company can live with a known cost. It struggles with an unknown and potentially unlimited cost.
Part 7. Product liability. Let us turn to product liability. This seems the most obvious legal tool for defective AI products.
It is important, but it has limits. Traditional product liability was designed for products like cars, household appliances, machines, toys, and medical devices.
The basic rule is that a producer can be strictly liable for harm caused by a defective product.
Correct. The victim usually has to show that there was a product, that it was defective, that the defect caused harm, and that the defendant qualifies as a producer.
That sounds straightforward until we talk about AI.
Exactly. AI challenges all three core concepts: product, defect, and producer.
Is software a product?
First, what counts as a product? Traditional product liability law usually focuses on movable physical objects, but software can be embedded in a physical object or exist independently.
So car control software may be easier to treat as part of the car.
Yes, that's embedded software. It's closely connected to the physical product.
What about a cloud-based AI service that a hospital accesses online?
That is more difficult. It may look more like a service than a product.
And what about an over-the-air update to a vehicle?
That's another difficult issue. The original product may have been put on the market years ago, but the update can change how it behaves today.
So the law must ask whether the update is part of the original product, a new product, a service, or a separate source of liability.
Exactly. The product-service boundary becomes blurry.
Why is it so hard to separate products from services in AI systems?
Because they interact continuously. A smart medical device may contain hardware, embedded software, cloud-based analysis, remote updates, third-party data, and ongoing technical support.
So, if something goes wrong, it may be impossible to say this was only a product problem or this was only a service problem.
Exactly. The traditional distinction becomes artificial.
Non-EEA software and direct downloads. What happens if a user downloads a software update directly from a company outside the European Union?
That can create practical problems. With a physical product, there may be an importer or distributor located within the European Economic Area.
But with a direct download, there may be no local intermediary.
Correct. The victim may have nobody within the EEA to sue easily. That raises issues of jurisdiction, enforcement, cost, and practical access to justice.
What is a defect in AI?
Now, the second concept, defect. How is defect usually assessed?
Traditionally, defectiveness is assessed by looking at the safety expectations of an average consumer, considering all relevant circumstances.
So the question is not whether the product is perfect.
Exactly. The question is whether it provides the safety that people are reasonably entitled to expect. How does that work with AI?
It becomes difficult. Suppose an AI system makes an unexpected decision because of self-learning. Is that unexpected decision a defect, or is it an unavoidable feature of a complex AI system?
For example, an autonomous vehicle misclassifies a person in an unusual costume as a roadside object.
Exactly. We need to ask whether the system should reasonably have been able to handle that situation, whether the risk was foreseeable, whether adequate warnings existed, whether the system was used in an appropriate environment, and whether safer alternatives were available.
And there is also the development risk defense.
Yes, a producer may avoid liability if the defect could not have been discovered using the scientific and technical knowledge available when the product was put in circulation.
So if nobody in the world could have known about the defect at that time, the producer may be able to avoid liability.
Potentially, yes. This may become more important for sophisticated AI products because some risks may only become visible after long-term use, large-scale deployment, or unexpected data patterns.
That sounds difficult for victims.
It can be. Even if the victim proves that a system was defective, the producer may argue that the defect was undiscoverable at the relevant time.
And then there's the third concept. Who is the producer?
Exactly. In traditional cases, the producer may be relatively clear, but in AI systems, many actors may contribute.
Hardware manufacturer, software developer, AI model provider, data provider, cloud provider, platform operator, system integrator, and update provider.
Yes, plus the company that deploys the system and the user who configures it. So the traditional image of one producer putting one finished product on the market doesn't fit well anymore.
Correct. AI products are often evolving ecosystems rather than fixed objects. Post-market control. Traditional product liability focuses on the moment when the product is placed on the market. Why is that a problem for AI?
Because AI systems may change after that point. Producers may push updates, add new functions, modify the cloud model, collect more data, or alter system performance. So a product sold in 2024 may behave differently in 2026.
Exactly, and the producer may still have some control over those changes.
But not full control, because the system may also depend on third-party data, environmental inputs, self-learning, and user preferences. Precisely, that's why the producer's traditional role becomes diluted. The producer may retain some control, but not exclusive control.
Part 8. Contributory conduct by the victim. We have spent a lot of time discussing defendants, but what about the victim's own behavior?
That's called contributory conduct. It means that the victim's own actions may have contributed to the harm.
For example, the user failed to install a security update.
Exactly. Or they changed default settings, disabled a safety feature, incorrectly installed smart home components, or added incompatible digital content.
Can this reduce compensation?
Yes. Depending on the legal system, the court may reduce compensation according to the victim's contribution to the harm.
Let's take the smart home example.
Suppose a homeowner buys a smart fire alarm system. The instructions clearly explain how to connect the smoke detector, the central hub, and the backup power source, but the homeowner combines the devices incorrectly.
Then a fire occurs and the alarm fails.
The court may need to balance two things. First, was the system itself defective? Second, did the homeowner fail to meet the expected standard of care by ignoring clear instructions?
So the producer may be 60% responsible and the homeowner 40% responsible.
That's one possible outcome. And what about two autonomous vehicles colliding?
That's different. There, two similar technological risks meet. Both vehicles may have systems, operators, users, updates, and possible defects. The analysis is more symmetrical. Part 9. Prescription. Time limits for claims. Now let's talk about time limits. This seems less exciting, but probably very important.
Very important. Prescription means the time period within which a victim must bring a claim,
Why is this especially difficult with AI?
because it may take a long time to discover the true cause of harm.
For example, a person knows that their smart medical device malfunctioned, but it takes months to determine whether the cause was the hardware, software, an update, or external data.
Exactly. The victim may need expert analysis, log files, source code review, and investigation of system versions.
And if the prescription period is short, the victim may lose the claim before discovering the cause.
Correct. The claim may be cut off prematurely, even though the victim had no realistic way to identify the technology as the source of harm earlier.
So AI complexity can turn time limits into a serious access to justice problem.
Yes, especially when the evidence is technical, expensive, and controlled by others.
Part 10, procedural challenges. We have talked about substantive law, who is liable and why, but what about procedural law?
Procedural law concerns how the case works in practice, who must prove what, who has access to evidence, how experts are used, and how courts evaluate technical information.
So even if the law says a victim should be compensated, the victim may still fail because they cannot get the evidence.
Exactly. That is why procedure matters so much.
Information asymmetry. What is the main procedural problem in AI cases?
Information asymmetry. The victim often does not have access to source code, system logs, training data, model parameters, internal testing reports, or software update history.
But the company may have all of that.
Yes, the producer, operator, platform, or cloud provider may control the information needed to prove the claim.
And that can make a legal right meaningless in practice.
Exactly. A right without access to evidence can be very difficult to enforce.
The medical malpractice analogy. Earlier, you mentioned medical malpractice as a useful comparison.
Yes, in medical malpractice cases, patients often face a similar problem. They may know they were harmed, but they don't know exactly what happened during surgery, treatment, or diagnosis.
The hospital has the records, the technical knowledge, and the experts.
Correct. Some courts have responded by easing the victim's burden of proof, requiring evidence from the party that controls it, or drawing negative inferences when records are missing.
And something similar might happen in AI cases.
It might. Courts could become more supportive of victims who cannot prove every technical detail because the relevant evidence is controlled by the technology provider.
But this will vary across countries.
Very much. Different member states have different procedural traditions, different standards of proof, and different approaches to disclosure and presumptions.
Harmonizing burden of proof rules. What could the European Union do about that?
One possible approach is to harmonize certain rules on burden of proof. For example, rules on when companies must preserve logs, when victims can request access to technical records, and when courts can presume causation or fault.
That would reduce the risk that the same AI accident produces very different legal outcomes in different countries.
Exactly.
Part 11, insurance. Finally, insurance. Some people say that the answer to AI liability is simply mandatory insurance. Is that enough?
No. Insurance is important, but it cannot replace clear liability rules.
Why not?
Because insurance can answer the question, who pays the victim first, but it cannot fully answer who should ultimately bear the cost.
Can you explain that with an example?
Suppose an autonomous delivery robot injures a pedestrian. The robot operator's liability insurance may compensate the pedestrian quickly, but afterward, the insurer may want to seek recourse against the software developer, the hardware manufacturer, or the company that supplied a defective update.
So insurance can pay first, but the legal system still needs to determine final responsibility.
Exactly. That is why insurers need clear liability rules too. They need to know whom they can pursue after paying a claim.
First-party and third-party insurance. What is the difference between first-party insurance?
First-party insurance covers the insured person's own losses.
For example, a homeowner buys insurance for damage to their own smart home system.
Exactly. Third-party liability insurance covers the insured person's legal liability to others.
For example, the operator of a drone buys insurance in case the drone injures someone.
Correct.
And sometimes both can be combined.
Yes, a victim may receive quick compensation from their own insurance, and then the insurer may seek recourse against the responsible party.
Mandatory insurance and compensation funds. When might mandatory insurance make sense for AI?
Probably for systems that create high or catastrophic risks, such as autonomous vehicles, drones, medical robots, industrial robots, or AI systems used in critical infrastructure.
And what are compensation funds?
They are funds that may compensate victims when insurance is unavailable, insufficient, or the responsible party cannot be identified.
For example, if an uninsured autonomous system causes harm.
Exactly, or if the damage is so large that insurance limits are exceeded.
Insurance and moral hazard. But there is a risk that insurance makes companies less careful.
Yes, that is called moral hazard. If a company thinks insurance will always pay, it may reduce investment in safety, updates, monitoring, and cybersecurity.
So the law must make sure that insurance doesn't weaken the duty of care.
Exactly. Insurance should support compensation, not replace safety incentives.
Data-driven insurance. How might AI change insurance itself?
Traditionally, insurers use historical claims data to estimate how often accidents happen and how severe they are.
But AI systems generate huge amounts of data.
Exactly. Future insurance may use very granular risk profiles based on real-time data, system logs, sensor data, software versions, update history, cybersecurity indicators, and usage patterns.
So insurance may become more dynamic.
Yes, premiums and risk assessments may be based on how a system is actually used, not just on broad categories.
But then access to data becomes very important.
Absolutely. Insurers may need access to logs and operational data to price risks and process claims, but that creates questions about privacy, commercial confidentiality, data ownership, and discrimination.
And there's also the question of cost efficiency.
Yes, if every insurance claim requires months of expert analysis of source code, sensor logs, and cloud data, the claims process becomes expensive and slow.
So a good insurance system must not only provide coverage, it must also process claims efficiently.
Exactly.
Part 12, a full example, the smart home fire. Before we finish, can we apply everything to one full example?
Great idea. Let's take a smart home fire. A homeowner has a smart smoke detector connected to a smart hub, a cloud-based monitoring service, and a mobile app.
A fire starts in the kitchen. The smoke detector does not trigger an alarm, the fire spreads and causes major property damage. The homeowner is injured while escaping.
Step 1, damage.
There's personal injury and property damage. Both are usually compensable. What about lost data from the home security system?
That may be harder. Data damage may not clearly fall within traditional product liability protection.
Step 2, causation. We need to ask why the alarm failed. Possible causes include faulty wiring, defective firmware, a software update, a cloud outage, a sensor malfunction, incorrect user settings, failure to replace batteries, or an installation error.
Step 4, fault. We ask whether the manufacturer, installer, cloud provider, or homeowner failed to meet a duty of care. Did the producer test the system? Did the installer follow instructions? Did the cloud provider maintain service reliability? Did the homeowner disable alerts?
Step 7, product liability. Was the smoke detector a product? Probably yes. Was its embedded firmware part of the product? Possibly. Was the cloud monitoring service part of the product or a separate service? More difficult.
Step 6, contributory conduct. Did the homeowner ignore clear instructions? Did they fail to install an important update? Did they combine incompatible smart home components? If yes, their compensation may be reduced.
Step 7, procedure. Who has the evidence? The manufacturer may have firmware records, the cloud provider may have server logs, the installer may have installation records. The homeowner may have app settings. The victim may need access to all of these. Step 8. Insurance. The homeowner's property insurer may compensate the homeowner first. Then the insurer may seek recourse against the manufacturer, installer, cloud provider, or other responsible parties. That one example really shows how every topic is connected.
Exactly. Damage, causation, fault, product liability, evidence, contributory conduct, insurance, and recourse all interact.
Let's end with the biggest lessons. What should listeners remember?
First, AI liability is not just about whether a machine made a mistake. It's about risk allocation across a complex technological ecosystem. Second, the most difficult issues are often causation, evidence, fault, and identifying the responsible actor. Third, traditional liability concepts still matter. Tort law, product liability, strict liability, vicarious liability, contract law, and insurance can all be relevant. Fourth, AI challenges traditional law because systems are complex, autonomous, self-learning, interconnected, continuously updated, and dependent on external data. Fifth, victims may need help through better logging, disclosure obligations, presumptions, burden shifting, and clearer procedural rules.
Can you give us one final one-sentence summary?
Yes, when emerging digital technologies cause harm, the legal challenge is to make sure that victims can be compensated without unfairly discouraging innovation, while ensuring that the people and companies who control, benefit from, or can prevent technological risks remain properly accountable.
That's a perfect ending. Thank you, Daniel.
Thank you. It was a pleasure.
And thank you to everyone listening. See you next time.